This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law's Intellectual Property Review. I'm Josh Block. Consumers.com posted a series of both sad and slightly funny photos. They're side-by-side comparison photos of children with inflatable swimming pools and water slides. A typical set includes first, a group of 4 or 5 children frolicking in an inflatable pool. The image looks like the definition of the word fun. This is the promotional photo for a children's swimming pool product. Next to that image is a second photo of a child, usually sad-looking, next to what is an actual size image of the assembled product at home. However, the product in the second image is either much, much smaller or the child perhaps is much, much bigger. The products in the photos are at the center of a false advertising and patent law dispute in the U.S. District Court for the District of Minnesota. I'm joined now by Jennifer Gaeta, a writer and editor of Bloomberg Law's Intellectual Property Law Report. Jennifer, tell us about the parties here. Who are Aviva Sports and Manley Toys, and what are the products that they make?
Sure. Aviva is a manufacturer as well as Manley Toys. They're both manufacturers of inflatable pools and slides, the kind that you would purchase for your typical backyard.
What is Aviva Sports' legal claim, and what are they claiming that Manley Toys has done with the images on the packaging of and the advertising for the inflatable pools and slides?
Well, Aviva brought several claims against Manley and a number of retailers. They had patent claims, and then they also have false advertising claims. And these false advertising claims come in 2 sets. First is under the Lanham Act, which is a federal claim, and the second is under Minnesota's Uniform Deceptive Trade Practices Act, which is the state claim. But for all intents and purposes, they're handled together as a false advertising claim.
Where do they sell these products, and what happened here?
The products are sold in Target, Walmart, Maynard, Kmart. And basically what Aviva claims that Manley Toys has done is on the products themselves, the picture representations on the products and in advertising for those products, that they misrepresented the size of the children so that the products, the pools and the slides, would look larger. So basically they're claiming that they manipulated the images to miniaturize children so that they would appear to have larger pools and slides for, your typical backyard use.
In reading about this case, I've learned much more about the varieties of inflatable swimming pools. Will you explain the difference between a fixed air and constant air inflatable pool and what's going on here with that?
Sure. If you think about your typical inflatable raft that you would blow and then plug with one of those plastic plugs, that's really what they're talking about, a fixed air product. It's going to be a smaller and less expensive product, whereas a constant air product is a product that needs a constant airflow in order to keep inflated. It would be more like a bouncy house, but for a pool or a slide. It would need a compressor that was continuously blowing air into the product to stay inflated. And those are going to be larger and more expensive. And the reason why that's an issue here is that Aviva brought claims against Manley Pools for both types of products, even though it only makes one. Aviva only makes the smaller fixed air products. And Manley Toys makes both. It makes the smaller fixed air products and the larger constant air inflatable products. And the court basically got rid of the claims for the constant air products on that basis because Aviva doesn't make those products. It deemed that it was not a competitor against Manley Toys in that realm.
Aviva argues that they wanted to get into that space.
They do. They claim that they went to Target and wanted to get into the constant air space, and were told that Manley owned that space. Unfortunately, though, at this juncture for the summary judgment motion, they didn't have enough evidence that the reason why they couldn't enter that space was because of the false advertising. Just because Manley Toys owned that space doesn't mean that the actual false advertising itself was the reason why they couldn't enter the space.
There have been a number of motions and opinions and parties that were involved here. Where are we in this lawsuit? Who's being sued and where are we now?
This case has really been whittled down quite a bit. First, the patent claims. They were stayed pending a reexamination, so they're not being talked about right now. Then the claims against all the retailers, the Walmart, Kmart, Maynard, and Fingerhut, all of those defendants have, on the false advertising claims, have been granted summary judgment on the basis that they are not actual competitors. In bringing this claim, Aviva is basically claiming that it's suffering a competitive injury. And as it's not a retailer per se, it's a manufacturer, the court deemed that that's not really a competitive injury with respect to the actual retailers. So those have been taken out of the equation. So right now, we're talking just about Aviva Sports versus Manley Toys, the other manufacturer, and the source of the allegedly manipulated false advertisement.
What does a plaintiff need to do to show false advertising under the Lanham Act?
First, you have to show that the advertisement itself, the whole advertisement, is literally false, or false by implication. Now here they're talking about literal falsehood because they're going to say that it's not implied that the children are smaller than the actual product, but it's literally false. It's literally misrepresenting the size of the children with respect to the actual product itself. And if they show that literal falsity, then the next element, which would be actual deception of consumers, is actually presumed. So it's in their benefit to actually show that the image is literally false, because then they get a pass on the next element, which is actual deception. Then the next thing that they have to show for a false advertising claim is materiality. They basically have to show that consumers are going to think that this is material to their decision to purchase a product, that in looking at the product and seeing how big it is and whether it's going to fit in their yard or whether their kids are going to be too big or too small for this product, that this would be material to their decision to purchase the product. The fourth element is interstate commerce, which is not really disputed here. And the final one is the injury causation, that the actual false advertisement caused Aviva an injury and that they need to be compensated for that.
What specifically does Aviva need to show that Manley Toys did?
Well, it's not so much what Manley Toys did, because this is not about intent. Although willfulness can be a factor in the court's or the jury's determination, it's not the deciding. It's not what makes this claim live or die. Basically, they need to show what is. Is the advertisement literally false? Is this falsehood something that would impact consumers? And did that cause damage? I mean, those are the sort of the basic things that they're going to actually have to show, which is centered on the advertisement itself and not really the intent of Manley Toys.
Aviva brought in a number of witnesses. What did the witnesses say, and how did they further Aviva's case?
Well, they had a number of expert witnesses, and then they had a couple of consumer witnesses themselves. The experts that they presented basically testified and had reports on all those elements that I just talked about. So they had one expert, for example, that extrapolated from the product's packaging and looking at the actual products in life, how big the children would have been vis-a-vis that actual product. So the expert basically estimated the age of the child, estimated the average height of that child, give or take, against the product, and determined that based on his extrapolation that the children would be the size of babies or toddlers when they were represented to be about 5 or 10 years old. Then they had another expert who did a consumer survey who basically showed that consumers were affected by the size of the product by having two different groups. They had one group that was shown the actual product as it exists in the marketplace. Actually, it was a web shot from a website. And then they showed another set of consumers what they deemed to be an accurate image of the product, where it was manipulated back to what they would think is more accurate representation. And it was very different. 69% chose Manley Toys first in that survey when they were shown the shot with the allegedly manipulated image, with the larger image, and only 25% showed that they chose Manley first in what was allegedly the corrected image. So there was that was the second expert, and then there was another expert that opined about how visual representations have an effect on consumers. Now that expert was actually removed from the case by the court, and the reason why was the court felt that the opinions and facts that expert had looked at were not based in enough reality, that he had not really testified as to what he was looking at, what consumer opinions he had been reading, and it just wasn't specific enough, and he didn't let the expert testify more generally on just how pictures can affect consumers, which may have been helpful for the jury. But the court basically said that would be, presumed, or that the jury wouldn't need any help with that. They wouldn't need any expert to say, well, if this picture was manipulated, then that would have an effect. And then the final expert that they presented was a damages and profits expert. That expert basically presented testimony of Aviva's damages, and that part was also removed from the case because the court, again, did not find that the expert's opinion and the evidence submitted was specifically tied to Manley's false advertising. While Aviva did show that they had suffered in the marketplace, they did not show that suffering was specifically tied to the false advertising itself. There was a causation link that was missing there. But the court did allow the expert's testimony to stand as to Manley's profits, and that's the other part of it. Under the Lanham Act, you can get both or either. You can get your actual damages, and you can also get disgorgement of profits. So that part is staying in, and then it will be Manley's burden to show any costs associated with that. So those are the 4 experts that Aviva put in. And then Manley had its 4 rebuttal experts, which basically didn't do anything themselves. They didn't present a consumer survey. They didn't present any evidence that their pictures were actually accurate, but they basically showed these 4 rebuttal experts to pick at, the 4 experts that Aviva had presented. And then Aviva also had presented a couple of consumers that were critical of the products.
What is the next step in this case?
The next step is either this case is going to settle or it's going to go to trial.
What do you think? Do you have any sense?
I think that since Manley Toys did not present, or at least, in this opinion, I'm only looking at what was presented to the court in its opinion, so I don't know everything that Manley might have up its sleeve, but at least in this, I didn't see a whole lot of evidence that they're going to stand behind their products and say that these images are accurate. So without that, basically just trying to knock Aviva out of the game, and Aviva wasn't knocked out. So they're still there. So I think that there's a good chance that this could settle.
Is that the best outcome for Aviva? Aviva hasn't been able to compete with Manley until now. Is the ultimate goal, and I don't know if you have a sense from what you read about this case, to compete with Manley, or to, knock Manley out, or to just earn back the profits that they've lost? Well,
they're not going to get their own lost profits or their own actual damages. That's out. The court already took that out. And I don't think it's to knock Manley Toys out altogether, but I think it would be to level the playing field, so to speak. Now, if you look at the consumer survey that they presented, even with the images corrected, Manley still was chosen as the first choice 25% of the time. Now, with the inaccurate image, or the allegedly inaccurate image, they were chosen 69% of the time. So even with the corrected image, there could be a variety of reasons why Manley would still be a preferable product, either because of the licensing that they have, the product placement in the shelves of the stores, and the actual product itself. So I don't think it's necessarily to knock them out of the market, but it could level the playing field. It could mean that Aviva gets a bigger market share if they were to either get injunctive relief to make Manley present more accurate images on their products themselves, or if they were also awarded Manley's profit.
Does this case have any greater implications?
Well, I certainly think it might for anybody who was following it, and for any other toy manufacturers or other entities out there that are advertising their products. It might cause them to pause and think of how they're actually presenting their products on their packaging. Now, no marketing or advertising for any manufactured product is going to put its own product in a bad light, right? They're always going to try to shine the best light on their product. But in using things such as Photoshop, or the other thing that was alleged in this case was not only that they've used Photoshop to change the images, but also that they used prototypes just for the photo shoots that were not actually the product. And it might curtail things like that if you're going to do a photo shoot of your product, that you should actually be using the real product if that's really what happened here. And also, if you're going to use photoshopping or airbrushing, it can't be to such an extent that you greatly manipulate the size of your product on its package or other qualities of the product.
That's Jennifer Gaeta. You can find out more about this case at BloombergLaw.com. You can find new IP podcasts each week at Bloomberg.com/podcasts. You can subscribe at both YouTube.com/Bloomberg Law and on iTunes. Thank you for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.